Welcome to the Grow Your Law Firm podcast, brought to you by Pilma. This podcast helps lead lawyers to more growth, profit, and freedom. Here is your legal marketing expert and host, Ken Hardison.
Hey, Grow Your Law Firm listeners. This is Gracie Howes from Pilma, and I'm excited to pop on today and share with you a special invitation. If you're serious about growing your law firm this year, you need to be at Pilma Super Summit, happening May 20th through 23rd in San Antonio, Texas. For more than a decade, we have brought together the best minds in legal marketing, management, intake, and operations, and now AI for one purpose: helping law firm leaders grow and scale their law firms. Attendees leave our conference with a real plan, actionable tools, strategies, and resources, not a brain clouded with conflicting messages and ideas. This isn't a conference where you sit and listen to theory all day. You will hear from real attorneys who are sharing what's working and what's not working when it comes to marketing and managing their 8-figure law firms. You'll be in breakout sessions built specifically for your role: COOs, marketing directors, firm owners, managing partners, leadership teams, so the right people get the right strategies. You'll have the opportunity to workshop real challenges, ask questions of seasoned marketers and leadership experts, and walk away knowing exactly what to implement and who owns it when you get back. We're going deep on AI, and not in a conceptual way. In our AI breakout, you'll have your laptop open, building, testing, and creating alongside experts. At our recent AI for PI event, attendees literally built their own custom AI tools during one of our breakout sessions. That is the level of hands-on that we are about. You'll also get to connect with attorneys and law firm owners who are scaling fast, sharing what's working right now, and building relationships that last long after the conference ends. The networking is intentional, the content is actionable, and the agenda is packed. If you want clarity, momentum, and strategy you can actually execute, join us at Super Summit this May in San Antonio. Registration is open now. Check the link in the show notes and secure your spot today.
Hey, it's Jenna, Membership Growth Advisor with Pilma. If you're serious about growing your law firm this year, don't miss your chance to book a free law firm growth strategy session with me. We'll break down what's holding you back, identify the biggest opportunities in your firm, and map out the next steps to accelerate your growth. No pressure, just real strategy and direction tailored to you. Click the link in the show notes to schedule your free session.
Hello, everyone. This is Ken Hardison, and welcome to another episode of Grow Your Law Firm. And today we have the privilege and honor of having Michael Roch, who is a consultant when it comes to partnerships. Michael, thank you for being here today, and hopefully I'm going to ask you a lot of questions that our viewers and our members at Pilma have a lot of, because, partnerships are like marriages. We all start out with the greatest intentions, and then sometimes they don't end up very well. So most of our viewers and listeners are PI lawyers or contingency-based lawyers, which is a little different than billable hour attorneys, because, many moons ago, 30 years ago, I used to read a lot of books about partnerships. And I think Helen Dorr was a big company out there that were big consultants, and everything they were talking about had to do with billable hours and, contribution this and contribution that and everything. And that's, in the PI world, most of what I see in partnerships is they just split it up according to percentage to partners. And I think things are changing now, because additional money is coming in, the more marketing, the firm. So what I really would like to do is, number one, just tell everybody a little bit about yourself and the company that you do, what you do, and then we can get into the questions.
Pleasure. Thanks, Ken, for having me and for the intro. So as you said, I've been working, living, and breathing in and for partnerships for most of my professional career. For the last 20 years, last year, I've focused on partner compensation in professional services firms across the board. So that includes law firms of all kinds of business models. So from the large firms that you've mentioned, where it's about the billable hour and some other things, to also PI firms and all kinds of law firms, patents and kinds of things. But we also look across to consultants, accountants, wealth managers, engineers. And in that, I've been really lucky in that I've worked with and helped firms across sizes. So from very small, a couple of partners, to hundreds or thousands, not hundreds and thousands of partners. And our practice is worldwide. So we typically start somewhere in Sydney our day, and we end somewhere in San Francisco. That's a pretty normal day for myself and my team. So pleasure to be here with you, and delighted to chat with you about partner comp and the specialties in the types of firms that's part of your audience. So
Absolutely. I've been in partnerships, 3 different partnerships in 40 years in law firm, and they all ended differently, and 2 of them ended very nicely, and one of them ended very badly. Just to be honest with you, but I learned a lot. The one in the middle ended badly, and I learned a lot. They talked to me before I signed the partnership agreement. So, what would you tell lawyers? The first thing is, if you think about partnering up with another lawyer and starting a firm, or bringing in another lawyer that won't come unless he's made a partner. What are like the most important things or the biggest mistakes you see lawyers make?
Yeah, great question. So 2 things on that. One, we're likely going to talk about a lot of things that compensation cannot solve or that profit sharing cannot solve.
Right.
So when you ask me about, if I'm a solo practitioner who's looking to add a second partner, the first question you've got to get really comfortable with is, am I talking to a good person? Not just ethically, ABA, ethics, but, morally good person, somebody who I trust, somebody who I think I can do business with, somebody who, based on what I know today, isn't going to, screw me over, to be blunt. That's because I cannot solve moral problems through compensation. Some firms like to do that, but you really can't. And especially in a small firm where you have got just a few partners, the personal interactions and that social construct that you will develop as you begin doing business together is super important. And then a good business result and a good compensation, a good profit share comes out at the end. So my first advice is, especially if you cannot drown in the numbers of partners, is you got to choose the right people. And the moral bit, the ethical bit is probably first and foremost. Second is, does this partner have the capabilities, the skills that I want my partner to have? And that can go in 2 directions. Do I want my evil twin, or do I want my wonderful twin who has the same strengths I do, and we come together and 1 + 1 creates 3? Or do I say, well, look, I've got the strength, for example, in business development, but I need somebody to help me execute. Then the strength is different. It's still 1 + 1 = 3. But I got to have clarity about what do I want in my partner or partners that I'm coming together with. And then thirdly, due diligence is a big word, right? So one is, okay, a background stuff like, how have you practiced in the past? Oh, you've come out of 5 firms and they've come apart. Well, gee, why is that? Is it you, or is it just, bad luck? That's the easy bit, I think. The other bit is spend some time in conversation about, what does that person expect from themselves in the practice and their lives? How are we going to do business together? Because especially if you're a sole practitioner joining a second partner, no matter what the power dynamics are, no matter who you're creating a new business together, and you want to have alignment of, does what we want to create together, does that align with what each of us wants to do? So that's the one bit. The second component to that is, besides choosing the right partner, is how the starting point is important. So adding a second partner to a solo practice is a very different game to adding partner number 7 to a 6-partner practice, or adding partner number 26 in a 25-partner practice, or adding partner number 101 in a 100-partner practice. So my answer will be different depending on what the situation is, but it does in the end come down to, first and foremost of all, the person that's in front of me. Do I want this person to be my co-entrepreneur?
Yeah. I mean, like 2 things I always looked at when I'm bringing somebody that's not a partner is, do they share my vision? And my core values is the most important thing to me, because there's certain things that I'm just not negotiable. Like how you treat clients, doing the right thing. Money's not number 1. It's probably number 3. I've just got certain core values that I'm not willing to negotiate, and I want a partner that has values, because they're willing to. You see this on TV shows and movies where one lawyer's pushing the envelope way up, like ethical shit, always pushing to the corner, and it's driving the other partner crazy because, hey, I wouldn't want that. To me, it's like getting married. It's got to be somebody that share the same value. I think that's very, very important. The thing I wanted to ask you about too is, I've been in firms before where firms break up, and they're usually 2 to 4 or 5 partners, What usually happens is somebody that's really a great litigator is getting great verdicts and making just a buku kind of money for the firm, and they don't feel like they're getting their fair share, and they end up leaving. I mean, what can you do to protect you? I've seen that at least 3 or 4 times in my life. And the lawyer went out and did it. And most of the time, they are pretty successful. I say one of them didn't do very well because he did business, but he really knew how to try a case and knew how to get me verdicts. And got a lot of referrals from other lawyers because he was so good. And he could take $1 million and turn it into a $5 million, which is, but there's people that just have that talent.
Yeah. I mean, it's a really complicated question, huh? Because the first question that we want to ask is, okay, well, why is that partner unhappy? How long has that partner been unhappy? And depending on what that is, that will help drive the answer, right? So if the partner is unhappy because they simply think that they're getting financially a bad shake, okay, my world and compensation, right? Profit sharing. Then, the question is, what do we do about that? But before we get there, let me back up. So we've been involved in a lot of partner compensation reviews for firms after the firm has seen a series of exits of partners. So there's always soul searching. Oh, geez, what went wrong? Why are all our good people leaving? We've got to do a partner compensation review because something has to be wrong with our compensation system. When you then start talking to the remaining partners, you begin to get yourself into sort of the idea of the firm, and you also perhaps, if you have the chance, talk to some of the partners who have left after the fact, after things have cooled down a little bit. Then you find out a couple of things. One is that compensation rarely is the primary driver of why I leave.
Really?
Yeah, usually, well, okay, so there's an exception to that I'll come to. But primarily, I leave for other reasons. Well, either I feel that, actually, I'll give you what's the biggest problem is. The biggest problem is I will leave if, in your example, I'm a great litigator, I try a lot of cases, but I don't think that my partners are as good as I am, or that my partners are not working as hard as I am. So if I'm working 20 hours a day and I've got 5 partners, then I'd like my other 4 partners to please work at least 18, right?
Right.
If I'm feeling that I'm doing all the work and 2 partners are just sort of sitting there relaxing, or often older partners who are sort of leaning back a bit and are saying, well, I've done all this and now I'm relaxing based on my reputation, but I'm still taking a big profit share. That will then lead to saying, well, okay, I just don't feel this is fair. The second reason is that the firm has no reason for being. So we have created this firm of 5 partners, your example, and we're doing PI, but there's no reason why this firm exists. Why are we doing firm as this business? And then how are we special? How are we different? What's our purpose? What's our vision compared to another firm? If that's fungible and, well, yeah, we're just good lawyers and we do our stuff, then I don't have that stickiness. So because I can no longer tie, if I'm that partner who's leaving, I can no longer tie my personal vision for myself to how my business is helping me support that. And then third, of course, is what I call, and this is, it's difficult to talk about this to lawyers, but if I feel that in the past crimes have been committed against me on the compensation front that have not been remedied, so now I'm getting sort of a fair share, but in the past, it was really unfair. And if I don't manage to forgive that because my partners have made me whole or something, then I will say, well, geez, then I'll start looking around and seeing if I can leave. Then the exception to what I've said, in that compensation is rarely the primary driver, is if the offer I'm getting from another firm is just so fantastically above what I'm currently taking out that even if I renegotiated my deal with my partners, I couldn't fix it. So for example, if I get an offer from PI firm down the street that says, look, you're making $1 million at your firm, come to us and you'll make 3 here guaranteed for 3 years, I have to take that seriously. So if people don't move for small amounts of money, people don't move for 10%. I mean, okay, some do, but that's crazy. Most people don't move for 10% more money at this level of compensation. Most people move for big sums of money. But that is most of the time it comes after the reason for why I'm looking in the first place, or why I'm receptive to having a second call after the recruiter calls me for the first time. Is that making sense?
Yeah, it's like I know with staff, it's like most of them don't leave because of money. They leave because they don't feel appreciated and they don't feel a bigger purpose doing makes a difference.
Yeah.
They don't feel like they're part of something bigger. So I guess that's
Exactly.
kind of like what you're talking about for partners too. It don't really matter if employees or partners. You got to feel
Yeah.
appreciated.
Exactly. I mean, in the firms, in the law firms outside of PI, PI is a bit of special animal, but in sort of your commercial law firms, huh? Often why partners leave is because the practice area that they're practicing in they no longer feel that the practice area in which they are is a strategic priority for the firm as a whole. Huh? So then they say, well, geez, my colleagues didn't pick your favorite department. I don't know, labor, right? Employment. They keep leaving because labor is not a priority. Then they will start looking for places where, hey, we're all about labor, right? So in PI, I see less of that, but in the commercial firms, that's one reason why people start looking around.
So I'll be honest with you. Over the years, I've come to the conclusion that if I started a law firm myself, what I'm seeing now is a lot of the PI lawyers, if they build up the firm, they took all the risk and everything, they got it to a certain point,
Yeah,
and then they got to have more lawyers that are making them partners.
yeah,
They're making them non-equity partners. What I found with lawyers is it's ego and money. They want their name on the board, or they want to be called a partner, or they want a lot of money.
yeah,
And some lawyers, I think, and you can tell me because you do this every day for a living, but I think some lawyers uh, being called a partner, even if it's a non-equity partner, and maybe you can explain that to everybody because I won't do a good job. But I think that sometimes that's more important than the money.
hmm,
The stage of being a partner. And to being a partner don't mean that you get to put your name on it's not just going to add names. But the deal is your business card says partner, you know.
yeah,
It don't say non-equity partner, it says partner.
yeah.
That's important. I mean, can you expound on that and tell me, are you seeing a lot of that now or whatever? And what's a good way to set up a non-equity partnership?
Hmm. That's a great question. So just so that we're talking about the same thing, when we think of equity partners versus non-equity partners, then equity partners are partners who share in the profits of the firm. So they take a profit share based on whatever is left over after everybody has been paid, including the non-equity partners.
Right,
Important, huh?
right.
And so basically, and all the non-equity partners who are going to listen to this, they're going to call me up and write me hate mail. But your non-equity partner is a in between an employee salary partner and an equity partner. Huh? So, and that's fine. The title is important to the clients, and the clients don't care and shouldn't care what my internal arrangements are in terms of how I structure my partnership. Right? None of the client's business. They have a partner in front of them. They know that they have earned the stripes, and that's fine. Of course, some clients do want to work just with the founding part, whatever, with the most senior people. That's a different. That's not your question, but. So the question always is strategically and operationally, do I want to have a two-tier partnership where I have equity partners and non-equity partners? Is that a good idea? Will that help me grow? The first answer to that is, well, if I can contain my equity, my profit share, then typically that's a good idea because if I don't have to share as much with somebody, then I make more money. So, a multi-tier partnership, at first answer makes economic financial sense. Enter now your statement, which was, I think people today perhaps prefer being a non-equity partner. They just care about the title, but they don't want to have the worries that an equity partner has, because the
Liability
big
and the liability because
and
you
I was just
share
going to
you
say, and
share
the
losses
liability.
too.
When, right, exactly. When things go south, depends a bit on the setup, but when things go south, typically the equity partners will take the brunt of that obligation, even if it's not an indemnity, even if it's not a professional insurance problem, if a malpractice. If in a year our cases don't deliver, then my non-equity partner continues making the salary, might not earn a bonus, but continues making the salary. My equity partner might earn zero. So I don't just take the liability, I take the economic risk that my firm does well. So now you ask me, okay, what do people prefer these days? And I think it really still does depend a bit. So some partners, some lawyers do want to have their cake and eat it too. So I get the partner title, I get a really big salary, I get a decent bonus if my case is delivered, but I don't have any of the hassles to deal with that my equity partners have to deal with. But I think I mean, I see you also have some gray hair. I have some, maybe not quite as much as you, but we always complain about the generation that comes after us. I don't think it's that black and white that the young partners all just want to have the title and nothing else. I think you have some very, very good entrepreneurs coming up who are very good lawyers and very good business people. And of course, that's what I look for in an equity partner, right? The non-equity partner doesn't have to be as good of a business person. My equity partners, I expect them to be really good business people too. So now your next question was, how do you set up a non-equity partnership? And I think, I mean, the how you do that structurally depends on how you structure your firm, legal, tax, that sort of thing. That's the technical side of things. But basically, it's not very difficult. It is you figure out a fixed amount that you want to pay, a competitive fixed amount that you want to pay your non-equity partner, and you figure out some kind of gain sharing, some kind of bonus, perhaps a tiny, tiny fractional profit share in the firm. You could do that. I've seen that's sort of a hybrid setup. You could do that. It's mainly about motivating that partner to do what you want them to do. If that is running cases, winning cases, right? You put the bonus to, what's your win rate? Huh? If you want the partner to say, look, I need you also, or I need you more than, I need you to win cases, but I don't need you to win as many cases. I don't need you to run as many cases. I also need you to be active in these 3 hospital organizations because that's where we will get our future cases. Then I can structure my bonus around that. So setting up a non-equity partnership that's doable. The question really is, what do you need for your firm? What do you need from your people? What do you need from your partners? And then last one, then I'll shut up. Is the non-equity partnership the landing point and there it stops? Or is the non-equity partnership a step to equity? Is it a testing ground to equity? You can do either, but you need to be clear which one it is because that will affect how you set up your compensation structure for that non-equity partner. Does that make sense?
And I've seen some people, I never made anybody pay me for equity in the firm. And I look back at it and I think I made a mistake. No, but seriously, I mean, I did more like work with me for 3 to 5 years. And if you do this, you got certain benchmarks. And if you meet, then I'll give you 10%. You know what I'm saying? I'll give you 10%, whether it be equity or not equity. But I never, I guess for equity, not equity, you wouldn't sell because you're not selling anything. But equity in the PI world, I see unless you're getting bought out completely by another firm, I hardly ever see associate lawyers have to pay money to buy into the equity of them. Is that normal or is that not good? Is that not good business?
It's a great question. So we see both is the reality. And we have to distinguish between 2 things. One is for a person to become a joint equity partner with me. I've ran a couple of consulting firms across the globe and all that sort of thing. So my equity partners must have money in the business. They must have skin in the game.
Right.
We can talk about how much. Might not have to be very much. But I'm sorry, if you're my partner, I've built up a firm and you're coming in as and share everything, share capital, share profits, then you take different decisions for the firm if you have money in the business than if you do not.
Yeah.
And I'm a firm believer that you need to have skin in the game if you want to be a true co-owner. That is both my personal view, and that is that's part of I guess, life philosophy, if you will, huh? If you're a true partner, then you need to have some skin in the game. We can talk about how much. If you have only $10,000 in your bank account, then I might not need more than $500 because that's a lot of money to you. Huh? And if the firm doesn't need the money, it's not about the firm needing the cash, right? That's it. It's the person having skin in the game so that we take good decisions for the business. Huh? So the second component to that is what I've just introduced, which is, does the firm need cash to operate? Now, most law firms, most PI firms don't struggle with cash flow once they are going. The first couple of years stink because I need a long time for my cases to gestate. But once they do, and I'm not greedy and take all the money out, I usually don't see a capitalization problem in PI firms, right? So if the firm doesn't need the cash of my partners to finance the firm or the next AI platform that I put in or whatever, then I don't need a huge capital contribution. Huh? So enter left the counterpoint, right? Pick Michael's evil twin, who says, well, capital partnerships are crazy in a professional services firm, in a law firm. Everybody should just come in, naked out. Meaning, your example, I give you 10%, but you don't have to put anything in. If you think you can make that work, fine. My experience is that people take better decisions when they have some cash in the business. And I think it is different yeah, I mean, it really depends on the economics of the firm too, right? If the firm is going and if you've built up, a firm that's kicking revenue 15 million a year, and I'm a brilliant associate, and you want to make me a partner, I mean, that 10% stake that you've talked about, that is worth something.
Yeah, I agree. I agree with you wholeheartedly.
I'd make you pay for it.
Yeah, and I've seen this done before too. Is like the associate wants to buy out, but he just don't have the money. So you say, okay, I'll give you 10%, but I want to finance it, and you would take the profits, the first $1 million of profits that you draw from is going to go back in. It's going to go to me because I'm selling you my 10%.
Yeah, I've no stress with that.
That way they still got skin in it, but you're not giving it away. You know what I'm saying?
Yeah, no, exactly. So I've got two tips on that to make that work.
Okay.
One, you got to structure it in such a way that my buy-in period is not 15 years for that 10%.
Right.
You've got to do it in such a way that you're done in 3 to 5 years, 5 years absolute max. Because nobody coming in has the patience to wait for the first dividend check or for the first distribution, whatever your structure is, to wait for a long period of time because, hey, I've got 10%. Second, it really depends. You got to be careful how you actually withhold that dividend or that distribution for that person to pay up that 10%. And I
Yeah.
don't mean legally, I don't mean contractually. What's important is how you show it on the paycheck or on the distribution schedule. Huh? If it just gets absorbed in this morass and they can't see, hey, I would have earned X minus 10 grand for this month's buy-in equals I'm now receiving. I've seen firms who keep that quite opaque so that the person never knew sort of how much they were paying essentially into the firm. If you want to go to the extreme, you can even say, look, we don't just withhold it. We pay you your full distribution, your full salary, your full bonus, but we require you to immediately turn back and write a check to us. That's the most explicit way of them paying that in. Because if they don't see it, it's like, oh yeah, they're withholding, and I don't know how much I have and what's going on. People make excuses. So how you do it, I think, is important, and it cannot be, you just keep that period as short as possible for them to pony up the 10%.
Yeah, and I think that's and you got the other thing is that money. I mean, I got to pay taxes on it. I could actually lose money by, if I find it, if I'm the one paying the finance, I could lose money. I call it phantom income. I've had to do that with IRS one year.
Yeah,
I paid off my line of equity, and I thought, well, I've done good. I paid off $500,000, but then I had to pay taxes on $500,000 that I didn't have. You know what I'm saying?
but for that, you have a good CPA
Yeah.
who, what you do is you say, look, here is the economics I want to achieve with my new partner. Please help me do this in a way that is reasonably tax efficient, and they will do that. What we do and what I would I would not suggest that a person who is not a full-time tax practitioner does that sort of themselves off the wing based on what they read or stuff. Either you do tax full-time or you don't do it. And for that, we've got the experts. So we constantly, bring in, no matter where we are in the world, we bring in the US, we bring in a local CPA, and wherever England, we bring in the chartered accountant to make sure that we don't screw that up.
So if you do bring in somebody, say, and however you do it with money or without money, here is something that I found out the hard way.
Yeah.
When you go to split up, if you ain't got if you don't have things covered, your partner can really put a wrench in your operations, like all of it. Like if you don't have some precautions in your partnership agreement, when one of the partners gets ready to break it up, and you don't agree to what they want to do, they can put you in receivership. I've had that done or threatened to me, and they had a very minority interest. Had like 10%. I had 90%, and they were going to just, I won't be able to pay my employees. I won't be able to pay my marketing bills. They'll be able to bankrupt me. So I kind of want you to tell me what I should have done, or tell lawyers out there what they should do if they got, minority shareholders that can really put a wrench in the operations, even though they only own 10% or whatever.
That's a good question. It's a bit of a tough question because it really depends on what we're talking about. I mean, whenever you go from a solo practitioner to a two-person or more operation, it's a different setup, right? You're not just adding a person; it's you creating a new business. And here, yeah, you've got standard things that you want to be able to cover in your partnership agreement. That's how decisions are made. That is how profits are shared. That is how capital is contributed. That is what happens if somebody isn't happy before it gets to a big problem dispute. And that also includes what happens if somebody says, look, I'm now exiting, right? I'm now either putting my shares or I'm resigning from the partnership or whichever. There, the key is to okay, with a two-person partnership, it's weird. Make it a three-person partnership, right? What we're protecting is the firm, huh? So depending, in your case, state laws, it's, non-competes. What do I do with clients? Can I take them? I mean, lawyers who specialize in partnership setups, especially professional partnership setups, will know A, what is market practice, and B, how far can we push those protections? But now I'm going back to what we said at the very beginning of this call is, as you know, as a lawyer, no contract will protect you against a bad person, right? If I want to screw you, I always find a way to screw you no matter what the contract says. So it does pay to do your due diligence, but again, depending a bit what the challenge was that you had, the standard stuff in a partnership agreement is what happens if somebody departs, what happens to profits, what happens to clients, what happens to how long I can all of that. Yeah. Depending on the state, depending on the country, you can regulate that sometimes more strongly, more or less strongly in your agreement. With three or more, it's interesting because if one person leaves, then if it's a true partnership, you're no longer a partnership legally, right? Then so then you've got some other legal consequences. But I'd be curious, actually, your 10% partner. I mean, what could the 10% partner possibly do to screw up your operations in such a way that it puts the firm under? I'd be curious to understand that a little bit.
Yeah, it's putting it in a receivership. Money that comes in goes into a trust account to you. You know what split up should be. You had to get a judge. Had to get a judge to do an order. I mean, she might not have been able to do it, but the threat of it was enough to piss me off.
Well, yeah, sure.
We worked it out. But I did not like the threat.
Maybe you just got a bad apple. I don't know.
Yeah, I think so.
But for that, you've got experts out there. You've got lawyers who do nothing other than look after partnerships, and they'll give you then the options that you have. I mean, putting something in receivership would mean that money is owed and some stuff that happens before then. With a 10% partner, the issue always is what degree of control does that person have? Did you give that person bank account access? How much independence did they have? How much systems access do they have? A 10% partner for the first 3 years, do you really need to give them all that access? Not so sure. 50% partner, if it's two of you, it's hard to say no, right?
Yep, good deal. Well, I've thoroughly enjoyed this. If somebody wants to get up with you or talk to you or ask you questions or hire you, Michael, what's the best way for them to reach you?
Best way to reach us is hello@mhpradvisors.com. I'm also on LinkedIn. That should be relatively easy to find. Michael Roch, Roch. Those two are the easiest ways. But I also enjoyed the conversation. Thank you so much for having me. And it's a wonderful space. So, yeah.
Thank you. And till next time, this is Ken Hardison, dedicated to you.
You have been listening to the Grow Your Law Firm podcast, the podcast that leads lawyers to more growth, profit, and freedom. Go to growyourlawfirm.com to find more ways to market and manage your law firm. Please leave us a rating and review wherever you listen to your podcasts.